Welcome to a special edition of the Sigma Podcast. Sigma Podcast this time will be interrupting its series, which we were doing on the use of AI in the gaming sector. And we will be getting back to that series. But given last week's judgment at the European Court of Justice, which has brought a lot of discussion in the Maltese ecosystem related to the gaming sector, we felt it would be wise to sit down, discuss with the experts, and find out different perspectives on this decision. To do that, in the first part of the podcast, I have two friends, two colleagues, two regulatory lawyers, Franklin and Michele. We thank you very much on behalf of Sigma for accepting this invite on such short notice.
And thank you for the invite, actually, Trevor.
We appreciate it a lot. We did get in touch with the MGA, and they were very kind enough to send us a statement about this decision. And so we will be starting the podcast by, I will read out the statement issued by the MGA, and from there we will then take on the discussion. So the MGA wrote the following. The Malta Gaming Authority notes the judgment in the case 7724 and is reviewing its implications. It is important to underline that the court did not examine, question, or assess the validity of Malta's regulatory framework. It is also important to emphasize that this judgment was strictly limited to the interpretation of Rome II regulation, which determines which country's law applies in civil and commercial matters involving non-contractual claims. The judgment delivered is highly technical in nature and must therefore be interpreted and understood solely within the specific context and circumstances of the case at hand, since similar cases may be subject to different exceptions under the regulation. The court did not pronounce itself on the substance of the underlying player claim. It does not relate to Article 56A, formerly Bill 55, which addresses a different legal context and reflects Malta's long-standing public policy on online gaming matters. In the absence of a harmonised EU framework for the regulation of gaming services, the Court of Justice of the European Union, the CJEU, recognises that member states have a margin of discretion in how they organise gambling activities within their territory. At the same time, the Treaty on the Functioning of the European Union protects the EU's fundamental freedoms, including the freedom of establishment, the freedom to provide services. Restrictive models based on de facto monopolies that run counter to the fundamental freedoms enshrined in the TFEU must be demonstrably necessary, proportionate, effective, and subject to continuous review, as continuously established by the CJEU. Malta's licensing regime has long operated on a point-of-supply basis, under which operators authorised in Malta may provide services across borders where they have a justifiable legal reason to do so, and comply fully with Malta's robust regulatory framework. This framework includes strong safeguards for responsible gambling, the protection of player funds, and the safeguarding of vulnerable persons. In the light of the narrow and technical nature of this judgment, Malta's position vis-à-vis player claims remains that operators licensed in Malta may continue to operate cross-border where they have a justifiable legal reason to do so. There is a lot to be said about this statement, a lot to be said about this judgment, and there are many questions which I have worked on in order to have this discussion. But I will start from the final part. And I'm going to repeat, Malta's position vis-à-vis the player claims remains that operators licensed in Malta may continue to operate cross-border. The MGA statement seems to indicate it's business as usual. Do you agree?
Thanks, Trevor. I think the MGA is correct here in that, this judgment doesn't I don't think that perhaps the media has portrayed it a bit too broadly in that in as to what it encapsulates ultimately, because the judgment is merely a reflection of Rome 2. The ECJ itself.
Wait a second. So, to play out a few parameters here for this podcast, we know what Rome 2 means. Mm-hmm. Do the viewers know what Rome 2 means? So if we're going to say something, Mick, let's beef it up. So what is Rome 2?
So I think there are two main pieces of EU regulations that are relevant in this discussion: Brussels 1 and Rome 2.
Okay.
Brussels 1 is the regulation regarding enforcement of civil and commercial claims, and Rome 2 is a regulation regarding the applicable law when it comes to tortious claims relating to civil matters.
Okay.
So essentially, what Rome 2 defines is the law of which state should apply if a consumer brings an action against a trader, for example.
Okay.
And that is what the Wunner case ultimately dealt with.
Okay.
The ECJ itself was already answering a preliminary reference from the Austrian courts. It was specifically addressed on certain matters, and there were already assertions made by the Austrian courts, which the ECJ didn't get into because that wasn't the subject matter of the questions made.
Such as?
And the main one being that the gambling contract between the gambling company and the customer was null and void. So already, the CJEU was under the presumption, because of the Austrian judgments, and this has been confirmed many times by the Austrian Supreme Courts, that the judgment was null and void, and therefore the claim was not based on contract, but based on tort.
Okay.
And that's therefore the application of Rome 2.
Okay.
That's not something that the CJEU went to, because the Austrian court has already decided that is the case.
Okay.
So ultimately, the court confirmed what Rome 2 says. But it doesn't get into, I think there's a lot of, mixing up with, for example, Brussels 1, which is what 56A generally is about.
Okay.
And therefore...
56A being Bill 55, as we know.
Yes. So ultimately, I don't think that judgment necessarily changes much. I don't think that's the Austrian framework and the Austrian issue is impacted by it. It confirms what the Austrian courts have said for a long time.
Okay, so if we have the ECJ, which is confirming what the Austrian courts have been saying for quite some time, if that is the case, do you think, Franklin, that Malta licensed operators can continue business as usual, as that statement was made by the MGA we just read?
So my opinion is that I'm very much aligned with what Michele said, because really and truly it's business as usual, in the sense that what the court was confirming is the applicability of Rome 2, where damages arise.
Okay.
Is where the player was resident ultimately, which was in Austria.
So there seems to have been a conflict between the point of supply and the point of consumption.
You could say that. However, I think the court interpreted the regulation in its strict
sense.
In a strict sense. Also, I think we need to just backtracking a little bit. So I think the point of departure should always be, whether for Brussels 1 or Rome 2, that the regulations, fully maximum harmonization regulations, with no discrepancy from one member state to the other, and the primacy of EU law and supremacy. So that should be the starting point.
Okay.
This is something that all member states, including Malta, signed up for. Okay. And we need to abide by what Rome 2 said, what Brussels 1 says, and that's it. So, now, on whether it's business as usual, yes, I think it is business as usual, because really and truly, the court, as you said, in the beginning statement of the MGA, it did not go into the substantive matters, whether there were actually damages or not. It just said, listen, if there are damages, according to how the Austrian court, domestic court, decides, because really and truly, this is part of the sovereignty principle. That's the national courts will decide then on substantive matters. It's always like that. I'm just giving my answer to a preliminary reference, to a preliminary question, where it's going to be like, okay, Austria will have where damage arises. It didn't go into there where actual damages. So gaming losses are actual damages, yes or no? It didn't go into that.
So
and that's something that the court will do.
So it didn't touch on the fact that there are so many claims of players from Austria which are right now are being contested in Maltese courts.
No.
So it has not touched on that matter.
No, because it's really and truly a preliminary reference, a preliminary question, and the court is restricted by that question.
Okay.
So it will not the remit of questions of substantive and facts of the case and circumstances, those are left in the national court, not in the JEU. Unless then it's an issue of fundamental human rights and, the treaty is being violated and all that.
Okay.
But that's why, in my opinion, yes, it's business as usual, because, listen, all the court was saying is that in this case, even though it can be shocking, and I think we're going to get into it when it comes to liability and director's liability, it's the damages arose where the player was resident.
Okay. Now, to throw a spanner in the works, so this judgment was delivered on the 15th of January. On the same day, the first whole civil court in Malta, Judge Francesco De Pasquale, delivered another ruling, and in which he said, basically the Maltese court rejected the enforcement of an Austrian judgment which was ordering a Malta-based licensed operator to repay 83,000 in gambling losses.
You want to go for that?
Michele, I think you were at the MGA at the time when this whole issue started to gain momentum.
I think I left just before, actually.
It's been that long.
It's been a while. But it's interesting that the judgments were delivered in such close proximity. But the reality of the thing is that they deal with completely different legal matters.
Okay.
Right? As we said, the Wunner judgment deals with Rome 2, and
this would deal with Brussels 1. Then,
the Pichler case deals with Brussels 1. So it's a completely different legal instrument. It does also deal a bit with Article 56A. However, Judge De Pasquale's judgment, a beautifully written judgment, ultimately decides not to rule on the basis of 56A. It does say, listen, I could have decided solely on the basis of 56A. However, I think the judge had the foresight to say base itself solely on principles of EU law. And it went into it, assessed what it can refuse on the basis of Brussels 1, not on the basis of 56A. And to quote one of the specific paragraphs says, enforcing the foreign judgment would be at variance to an acceptable degree with the legal order of the state in which enforcement is sought. So that's what that's why Judge De Pasquale decided to rule against it. Effectively, on the basis of two principles. The first being the principle that, listen, Maltese law already grants certain rights and obligations towards Maltese license holders. So the departure point of the Austrian courts is that the Maltese license is invalid, right? Of course, kind of what the Maltese court is being asked is confirm the Austrian judgment. Now, on the basis of Brussels 1, a judge can't go into the merits of the case.
Okay.
Right? And that is clear, and the judge repeats that continuously throughout the judgment. That he's not going to assess whether the Austrian judgment is right or wrong, and he doesn't question the Austrian judgment.
So he doesn't go into the legality or otherwise of Austrian gambling law?
No. Well, to a certain degree, he does, and there is a very separate case on that is currently at the CJEU. But to go back to Pichler, what he assesses is that in one instance, the Austrian judgment does affect the validity of the Maltese legal framework when it comes to gambling. B, it also assesses issues surrounding the applicability of the fundamental freedoms of the European Union, and that potentially the Austrian legal system, the Austrian gambling regime, is not
Compatible
compliant with 5060 FEU.
Okay, so if I may ask this question, so you said two interesting points there, but I'm going to latch onto the latter. In which specific, so it's Article 56 of the TFEU,
Freedom to provide services.
freedom of provision of services. Does he delve into the detail?
Yes.
Judge De Pasquale.
Yes. So,
Could you highlight that?
So one of the key things that Judge De Pasquale talks about is the Austrian system, right? Where there is a monopoly that is run by two entities, Lotteries Austria and Casinos Austria, or Austria Lotteries, whatever, something like that. And ultimately, he looked into even the ownership of Casinos Austria, and he's saying, the Austrian state owns 33% of the Austrian monopoly. The remainder is privately owned. And then he looked at, the very traditional CJU judgments, reflecting the limits to the freedom to provide services and freedom of establishment under European law that we're very familiar with, Lacanica, Gambelli, Stanlibet, and ultimately and most importantly, Fluctus and Fluendum, which was a very recent CJU judgment in 2019 regarding specifically Austria. And Fluctus, what it does kind of very indirectly, as the CJU does, question the validity of the Austrian framework, and that's what Judge De Pasquale looked at when assessing whether looking into whether the Austrian system is undeniably compliant with EU law, questioning that nexus. Interestingly, though,
I just checked the ownership of Casinos Austria is 55%. Saska, well, formerly Saska, now is the Allwyn Group.
Yeah.
And 33.2% is an Austrian state holding company.
Yes. And so Judge De Pasquale's point was, listen, the CJU cases generally look into the principles and principles of when member states may restrict the freedom to provide services and the freedom of establishment. And those include, there needs to be a certain level of proportionality, suitability of the measures, and ultimately, if whether a state is not promoting gambling or private ownership of certain gambling business, that needs to be consistent. Now he's questioning, the fact that the monopoly is given to a private enterprise, does that conflict with the perceived principles of Austrian law that seek to limit gambling and seek to limit that practice? Very interestingly, though, this was to my knowledge, the third judgment of Judge De Pasquale. In the previous two judgments, there was also another point that he raised. I think in Pichler judgment, Betway didn't raise this exception, didn't raise this point, so he didn't delve into it. But the other two judgments, which referred to PokerStars and someone else. It looked also into the fact that in Austria you also need to pay gambling tax. You pay 40% GGR, even though you're not licensed. MGA licensed operators are paying 40% GGR tax on their business in Austria. And very, very interestingly, Judge De Pasquale, he actually, when making this point, he used an exclamation mark. Like he was gobsmacked, surprised almost that there is the situation where the Austrian courts are saying this is illegal, give them all the money back to the operators.
But they want the tax.
But the Austrian state is very happy to accept the tax.
That raises.
Can I ask a question on this? Do you believe that is a form of tacit acceptance of the status quo? Taking the tax money?
Possibly, yes, but then we're delving into a new realm of separation of powers, and can you really, you know what I mean?
I'm asking for your opinion.
Sort of. What I wanted to raise. So I'm not entirely aligned with De Pasquale's judgment, and I'm not fully in agreement. Now,
Why?
of course, like if I had to give a dissenting opinion, I think this links to what I was saying in the very beginning about the supremacy and primacy of EU law.
Okay.
So Brussels 1, for the listeners, it's an automatic recognition of foreign judgments within the EU member states. So if there's a judgment being delivered by a judicial body in a member state, it needs to be automatically recognized, subject to certain exceptions. One of them is public policy. In any other member state. Issa, Judge De Pasquale uses the public policy argument, but public policy, when using this exception, has certain limitations.
Such as?
So it must be, and of course I'm referring to my notes, interpreted strictly, so strict interpretation, used exceptionally and limited to cases of manifest and intolerable breach of fundamental principles of the forum legal order. Now, I don't think, and correct me if I'm wrong, that he delves into detail on these exceptions when it comes to public policy. And it also begs the question, okay, how can we stretch the definition and interpretation of what is public policy in Malta? And that's why this judgment brought infringement proceedings from the European Commission. Because now the European Commission is sort of saying, okay, Malta is in breach of Brussels 1.
I don't think it's this judgment that brought.
No, exactly. It's not just judgment.
So this
Yes.
is. I think this is the beauty of the judgment in that it doesn't even reference 56A. It's 56A that brought the infringement proceedings.
Yes.
Now 56A.
He learned from.
I think what it does a bit weirdly is it implements what is called an ouster clause. It restricts the jurisdiction of the Maltese courts, and I think that is one of the principal breaches that the European Commission is saying that Malta is breaching Brussels 1, is breaching the mutual trust between member states when it comes to the enforcement of civil and commercial matters, because that's what 56A does. On the other hand, Judge De Pasquale is ruling solely on the basis of the public order principle in Brussels 1.
Okay, public policy and public interest. Are they one and the same thing? Are they different? Why? Maybe it's in the public interest that one way or the other the gaming sector is protected in this country, because it is in the public interest, given the value added that this sector provides to Malta as a country, as a community. So public policy, public interest, are they on the same level? Are they two different? Are they conflicting principles? Are they symbiotic? Are they hand in hand? Do they go together?
I think they're very much aligned, really and truly. But of course, it's a very grey area in the sense you can write many theses on it, to be honest, what is public policy. Initially, at face value, you would think that public policy is more in relation to, for example, the welfare state, free public healthcare, free schooling, free education.
Wait a second.
Wi-Fi, for example.
Wait. Now I'm going to delve a bit more into the politics of this.
Yeah.
And linking also to some of the questions which I put. The economic impact.
Yes.
You just mentioned welfare state, social security, public schooling, public infrastructure. Where does the money come from?
Exactly. So if you were to extend this interpretation and possible definition of what is public policy, definitely an economic element is there. The economic element and the value added which the gaming sector brings to Malta. It's undeniable, So one could definitely include the gaming regulatory framework, as robust as it is and as regulated as it is, into the public policy element. And I think that's what not just Judge De Pasquale, but also then our ministers and politicians have included.
Let's say government.
Yes.
I think, of course, public policy has the economic and social element, but I think ultimately what Judge De Pasquale was convinced of is the fact that you have an Austrian judgment where the initial premise is that Maltese law and the Maltese regulatory framework is inapplicable and is null and void and is irrelevant. And I think that is ultimately, an element of public order that Judge De Pasquale saw as being kind of,
But yes, and I completely agree with you over there. But then my opinion is that what Malta should have done, rather than 56A, for example, is infringement proceedings against Austria. Why wouldn't we go down that route? Because I think that would have been the correct procedure, rather than automatically not recognizing a judgment and then it's leading to infringement proceedings.
I'm very happy that you brought this up, because then there is a separate discussion. There's a bit of background that we can go into, right? And principally, is that previously the European Commission was very active in protecting the freedom to provide services and freedom of establishment within the EU by filing infringement proceedings against member states when they were violating these within the context of gambling, including online gambling, right? However, what happened, and this was actually one of my responsibilities when I was back in the MGA in 2017, the European Commission outright decided to deprioritize gambling. And it unilaterally, in what is something a bit of a political decision, even though the European Commission is not political, it decided to close all gambling infringement cases. That was in 2017. So it decided,
and even the expert group, right?
Yes, the expert group was closed. So at the time there were 6 or 7 infringement proceedings going on against countries on the basis of gambling services. All of those were, irrespective of the issue, closed by the European Commission on the basis of that it did not feel that it should prioritize gambling services. So now we're in a bit of an ironic situation where the only infringement proceedings related to gambling that there is the one that Malta is facing. And I think that is a bit of a ironic situation. Ultimately, it's not on the basis of gambling; it's on the basis of a breach of Brussels 1 or an alleged breach of Brussels 1. But that is the current situation. Austria itself had infringement proceedings on the basis of gambling.
And what has changed from 2017 till today? Has the legislation changed?
No. So actually, Austria had infringement proceedings back in 2009. Now, the records on this are a bit iffy, right? But the infringement was on the basis that Austrian law restricted gambling advertising solely to the monopoly holder, to the exclusion of all other EU operators. So the European Commission had issued infringement proceedings against the Austrian state, and the Austrian state eventually changed the law to accommodate. And the way the law was changed was something on the lines of that other companies may advertise in Austria as long as they provide the same protections that Austrian license holders provide. Fast forward to now, and that situation has been completely forgotten. Obviously emboldened by the fact that there's no European Commission action against potential breaches of the freedom to provide services, the freedom of establishment, and the court case that I also mentioned previously, Fluctus, which dealt with the Austrian monopoly situation, that is also very telling of the compliance of 56 of Austrian law and the Austrian monopoly with EU law. So that's the situation we're currently in.
We're going to take a short break and get back to the discussion in a few minutes. Thank you so much for joining the Sigma podcast. We'll be with you shortly. Welcome back to the Sigma podcast, which is looking at last week's winner decision, the decision from the ECJ with regards to a particular aspect of the gaming sector. The let's say Rome 2. We are on Rome 2. A very specific decision, which was also highlighted in the statement by the MGA and which was further explained by our two guests, Franklin and Michele, whom I thank once again for coming on the show in order to discuss this. In the third part of the program, we will be having an operator with us in order to discuss further the impact on operators. But before we get to that part, I would like to start where we left, where we spoke about how in 2017 the ECJ, well, the European Commission, took a decision on terminating infringement proceedings. Also, there was the decision by the European Commission to terminate the expert group, which was meeting regularly on gambling affairs. And now we see this decision by the ECJ. When I read it, the first note I wrote, Franklin, was, is the ECJ basically putting the ball in the member state court, to take action and look at harmonizing? What do you think?
Yeah, so basically, within European Union law, harmonization can take place either through positive integration. So, for example, by regulation, directives, etc. Or the opposite, negative integration.
Which would be?
Negative integration, and this is very common, especially in tax cases, and that's my area of expertise, actually. So tax is sovereign within the European Union, meaning the member states have absolute sovereignty when it comes to deciding what their tax rate is going to be, how the tax system is going to be, and that's embedded in the Treaty for the Functioning of the European Union.
Okay.
However, there were cases where, even though tax is sovereign, there was discrimination.
Okay.
So what happens then? The Court of Justice of the European Union would consider a particular tax measure, for example, as breaching the treaty. And when there is that breach and there's judgment on by the European courts, that's when the national member state would need to change its laws, and like that, harmonization is achieved through negative integration. Called negative because there's a judgment saying that listen, this tax measure is in breach.
So the ECJ would be instigating
exactly
okay.
through its judgment, basically.
Okay.
And this is quite common when it comes to tax.
Okay.
Now over here, it could be the case that we're experiencing negative integration as well by these judgments.
Okay.
And really and truly, gaming is similar to tax law in the sense because we don't have a directive which is fully harmonized, minimum harmonized, or a regulation which is maximum harmonized.
I think, Michele, correct me if I'm wrong, the closest we got was to a green paper on technical.
Yes, well, there are a few non-binding European standards, but unfortunately, my perspective, there hasn't been a lot of take-up.
So for example, let's.
In fact, if I'm not mistaken, Franklin, because I worked in Brussels at the time, 2006, in the debate for the Services Directive, gambling was specifically excluded as well. So
I mean, it creates a huge discrepancy and conflicts of law because let's take, for example, the very recent regulation, the Markets and Crypto Assets Regulation, MiCA. That makes it fully harmonized. One regulation which harmonizes crypto service providers across all EU member states. And over there, it's clear. Directly applicable, you don't even need...
It gives certainty.
With gaming, it's not the case, and I don't think it will ever be the case. But negative integration might be possible through these judge-made decisions, basically.
Okay.
So I think there is that push from the European courts.
But is it an ideal situation? Michele, especially you with a background in regulation, Michele.
I have a bit of a different opinion on kind of where the CJU has been going, in the sense that even as far back as, Gambelli, the CJU has always said kind of there are very clear differences in member states based on religious, social, cultural backgrounds when it comes to gambling, and therefore there are restricting the freedom to provide services is justified as long as they meet certain requirements, and that has always been very consistent in CJU judgments. So and the CJU itself has always been extremely cautious, even when faced even when it wanted to pass on the message that listen, this particular measure is not exactly compliant with European law. It has been very cautious in kind of how to profess that, and it always pushed back to member state courts. I think one of the most interesting ones to read in that sense is, for example, the Sporting Gods case, Hungary. You know, where the CJEU kind of strongly indicated, listen, these are the requirements, but listen, it's up to the national courts now to interpret. And in that case, for example, the national courts did interpret that Hungarian law wasn't compliant with European law. But it's national courts that have to decide that.
Yes.
So the CJEU hasn't taken an active part in that push, and has taken a bit of a step back from being too insistent.
Okay. So we've spoken about the ECJ's role in this, but when we're looking at the decision itself now, let's go into the actual decision. And the court, the ECJ, said that spoke about the actions aimed at the directors of the company and what those implications could be vis-a-vis the directors. You made a reference in the beginning on the role of directors. Could you maybe explain a bit more in light of the first conclusion?
Yes. I mean, so this it's a known fact. Like, the directors are personally liable.
Yes.
Really. And not just, especially in fields which are more of criminal nature, for example, money laundering or financing of terrorism. Over there, the fines that can be up to imprisonment, on the directors is massive. So the risk is massive.
Okay.
So this boils down to the risk appetite of the company and of the directors, really and truly. If the directors are being faced with personal claims against them of 50,000, they might say, you know what, I'm going to take the risk. So, but if then we're looking at imprisonment or that, then the risk might be hedged.
Your risk appetite changes. Then.
Exactly. So it really depends on that. But the role of a director really and truly cannot be a passive one. Mm-hmm. It has to be always active. So in my opinion, and if I'm a director on a company which is operating in Austria, for example, I would make a thorough risk assessment and I would say, okay, is this worth the risk? Because then, of course,
is the juice worth the squeeze?
Exactly. It's not just and risk an enterprise risk assessment. Enterprise-wide risk assessment is not just about your personal liability, it's your reputation, your social risks, everything else that you have to take in consideration. But I think what is most important is that the director should take consideration of all these risks and take an active role. Okay. It should never be a passive role. So ask questions internally with your compliance officer, with your legal department, and it's something that will definitely protect any director, really and truly.
Well, I think that is where kind of like Warner, I think, has created quite a bit of a reality check, right?
Okay.
Yes.
With directors, because it does speak mainly about directors' liability and it's the directors themselves that really need to pay attention to their risk appetite here. Also, when it comes to where their assets are located, right? Because ultimately, this is what the game is. What a lot of Austrian claimants have been extremely creatively trying to do is, okay, so the company is protected in Malta, but where are the other assets that we could potentially look at? Mm-hmm. If it's not the assets of the company, is it the assets of the directors? If it's not the assets of the directors, maybe it's of the payment service providers, of the suppliers, of all of that. I mean,
so they're going after the suppliers as well?
Let me take you back to a case that today everyone learns about in university when they're studying law, right? ZTURF. The ZTURF case ultimately included measures taken by the monopoly.
This is the French horse racing.
That one,
PMU.
2007. Right. Ultimately, that action was the French monopoly taking action against the data center hosting a private horse racing operator licensed in Malta. They were issuing fines against the data center. They would have liked to attack the company directly, Zeter directly, but everyone was seeking all potential avenues to recover, and that's what's happening here as well. It's not just about directors; it's also about the entire ecosystem. That companies need to be careful because it's very broad, and there's also I would say one of the most concerning cases right now. There's a Mr. Green case at CJEU that is a preliminary reference from the Austrian courts about a regulation, the European Account Preservation Order, where basically this Austrian player has sought freezing order against all of the company's bank accounts in multiple EU countries, in Luxembourg, in Malta, in Ireland, and so on.
And
so
this is
forth.
Mr. Green, which is now owned by Will Hill, right?
Yes. That case, that was subject of an AG's opinion late last year, which basically, and very worryingly, is kind of saying, the European Account Preservation Order regulation is there kind of to seek redress when there are situations where enforcement of a foreign judgment seems to be problematic, right?
Okay.
Or cross-border enforcement seems to be problematic. And the AG in that situation says, listen, 56A of Maltese law is potentially a deterrent to the enforcement of foreign judgments. So, this preservation order might be worthwhile, and that is quite a worrying statement.
Because if you cut the flow of money, you're cutting off a good chunk of the operations of that entity. You mentioned that there's this case going on at the ECJ. Are there a number of cases right now which merit possible mention over here during this podcast?
Yes, there are a few. There's a preliminary reference from Maltese courts. There's a preliminary reference from German courts that has been very impactful in suspending cases in Germany. So Germany is quite different to Austria in that it's not as clear cut. There are situations where the German courts have blocked player claims because of various reasons. Germany is a free market now. Mostly.
Mostly? Maltese we say mostly.
I think, German regulation I think is one of the toughest out there.
Okay.
It's extremely challenging. But ultimately, there is an opportunity for anyone to get a license in Germany if they really want to. Again, with regards to the player claims in Germany, there is a court case that now most courts in Germany are kind of waiting the outcome of and have suspended proceedings of player claims in German courts until the outcome of the ECJ judgment.
Which court case is this? ECJ?
That's a typical case.
Typical,
yeah.
okay. Their Malta-based license?
Yes. There's also a preliminary reference from the Maltese court as well, the European Lotto. And the question that is posed by the Maltese courts is, can a Maltese court determine whether the law of a foreign country potentially breaches the freedom to provide services, and the second question being, are restitution claims with regards to EU licensed operators abusive of EU law or no? And there has been an AG's opinion there, and it's a bit of a mixed bag, right? On one hand, it's saying that no, player claims are not abusive in and of themselves. It's a standard, civil claim. So they're not abusive of EU law. But on the other hand, it does say that national courts can, assess the validity of another country's potentially non-compliant legal instrument.
There is procedure in fact laid down. The infringement procedure that a country can take another country to court based on infringement proceedings, and I think that's what Malta should have done in the first place. Take Austria against Austria, infringement proceedings against Austria,
Because of the monopoly.
rather than not recognizing a foreign judgment and potentially be in breach of Brussels 1.
So you're saying taking a bit more of an aggressive approach.
Yes.
Attack is the best form of defense.
And it's a safer procedure to follow.
Why is it safer?
Because in my opinion, not this recent judgment of Judge De Pasquale, but the first judgment when he invoked Article 56A led to infringement proceedings by the European Commission.
Against us.
Yes.
Against Malta. Okay.
Infringement of Brussels 1. Brussels 1, just by way of repetition, is the automatic recognition of foreign judgments.
Yeah.
So
Okay.
it's like we took ħadna regola fidejna.
We took the law in our hands.
Exactly. And we sort of course, I'm speaking very.
You're speaking in broad terms.
Very broad terms. We said, I'm not recognizing this foreign judgment. Brussels 1 can, let's park that for a while. And I think that was the wrong approach.
So maybe the correct. It's like we took a half step forward.
Yes.
But then we went back.
Exactly.
If we really believed. Do we really believe? So the next question is, do we believe in Bill 55? Do we believe in Article 56A? Because if we do, then why didn't we go on the attack?
I think that's what we should have done. We should have taken Austria, started infringement proceedings against Austria rather than not recognizing an Austrian judgment and potentially risk breaching Brussels 1.
It's an interesting take. Maybe in the near future we'll get Antonio Guillo on the podcast to discuss this, because he had a central role in dealing with Bill 55, Article 56A, and if I'm not mistaken, he's a lawyer in a number of these cases in the Maltese courts. But that's hopefully in the near future.
It warrants us, I think, not just one podcast.
It warrants a whole discussion.
A whole working group, I think.
It warrants a whole discussion. Now,
however, I think strategically,
you want to put in something? Okay,
strategically, infringement proceedings against another member state, apart from the diplomatic implications of it, you don't really know how the court is going to go, right? And it's a bit of a gamble on both sides. So I think that's why both Malta and Austria are kind of like pussyfooting around it. Because that's also the reason.
That's another interesting take.
Yes, that's also the reason why Austria hasn't brought administrative or criminal proceedings against Maltese companies operating in Austria, right? Because the standard of proof
is criminal and beyond reasonable doubt
is much higher. Exactly. And if you risk ultimately going to the CJEU for the CJEU to judge whether your law is compliant with EU law or no, it could go either way.
So basically, if I'm looking at this correctly, at this stage, it seems everyone is like dancing around the issue without really jumping into the nitty-gritty of it. Am I correct?
Yes, I think so. And the political implications, of course, needs to be assessed.
So, we're talking about political implications, and we've got the last few minutes of this discussion. The president in the United States loves to negotiate, loves to see how he can get better deals. So, what do you think? So we said Malta held back from an aggressive approach, Austria held back from an aggressive approach, Germany and Netherlands, who also have these player claim issues, have held back. What is stopping the member states from sitting around the table and really discussing this issue? Is there an interest, do you believe? I'll frame the question in that way. So for your opinion, do you believe that the member states want to resolve this issue? Or are we happy with the status quo with all of this uncertainty in courts, which has been going on? Plakanik Hangambelli was 2006, 2007?
Before that.
Okay, so we've been pussyfooting, to use your words, around this issue for 18 years now. 18 years. The citizens are the ones who seem to be. That being said, I do have an issue with people who gamble on websites and then want their free bets.
Yes.
So let's also put that on the table. Wanting free bets in this sort of manner, I do have a bit of an issue with that.
Likewise.
But let's forget all of that.
Can I make a really small point about that? Because actually, another public order argument is that what the player claims are encouraging is extremely potentially damaging from an RG perspective, because what it's saying is it's okay that you lose your life saving playing because you can recover your claims. That is extremely dangerous from a public order perspective. It's almost promoting gambling. Don't worry about it. Gamble all your money. Then we'll take them to court and
yeah. We don't know when we'll resolve it. We don't know what percentage we're going to keep of whatever you win, if you win. But gamble and we'll get your money back. We might get your money back. But so we're looking at all of this. At the end of the day, companies are losing out because of the massive expenses involved. We're going to have an operator here soon, and I will ask the question on what does it cost for operators to fight these issues? Because it's well and good that we have Malta as a country, as a government, protecting the industry to the best of its ability, but operators need to do their part as well. So operators are suffering one way or the other. Residents, citizens of the EU are suffering also. So what is holding the politicians and the experts and the technocrats from sitting down and discussing this issue? What do you think? Up to you, whoever goes first.
I think really it's a country by country approach, though, because although there are obviously very different kind of opinions and perspectives between Malta and other member states, if you look at open markets and regulated regimes, the likes of Denmark, Netherlands, Sweden, and so on, I generally feel that Maltese public policy and those are other jurisdictions with regulated and freely accessible markets subject to very strict regulation, but so be it. I think that aligns perfectly in the sense that the MGA, to my knowledge, cooperates very closely with these other regulators. I don't think there's any contention there.
Yes, but Michele, let's not again pussyfoot around the issue. The regulators can only reach here. At the end of the day, it's the politicians who set the political agenda and who legislate.
Yeah, but that is why it's cases like Austria that become problematic, because Austrian law does not allow for a free market. But if member states allow for a free market, then I think the friction is very much reduced and minimized. And we see that in newly regulated markets like Netherlands or mature markets like Denmark. So I don't think there is as much friction there. So it's a question of what does the member states want to empower? If maybe there's a bit of a protectionist approach with a monopoly that maybe is not justified on the basis of the requirements set by the CJEU itself, that is where friction exists.
To add another dimension to the question, isn't this a case that maybe Austria's the pot that's calling the kettle black?
Mm-hmm. No, I mean, this is, as Michele was saying, it's very much country by country, and Malta, this issue, I think it's very high on our agenda because of its economic implications, social, whatever. Public policy, many implications. Unfortunately, though, I think because of, at the moment, I feel we have a bit of a global crisis with presidents wanting to invade other countries and purchase other countries, and tariffs going left, right, and center.
Without mentioning names.
Unfortunately, even I believe a lot in harmonization because it gives legal certainty and legitimate expectation, which is embedded ultimately in the treaty which all member states signed. So the irony is that why we haven't harmonized the gaming regulation, I don't know really, Julia. I think there are a lot of things, as Michele was saying earlier, religious, political, and all that. But I think we are creating a bit of a bit of a barrier ourselves for harmonization, and I can't understand how
When you say ourselves,
member states. For example, the crypto MiCA regulation was done in a matter of 2-3 years, which is AI, another thing. The AI Act, which is fully harmonized as well. So definitely, like, how can? Okay, I see AI that's being it's important, but I think gaming regulation is equally important.
And what surprises me is because between AI and gaming, maybe there's a tax issue from a gaming tax perspective, but then we've got crypto as well, isn't there? Over there, a tax issue. So what's holding us back on gaming? What interests? I do have a feeling of what it is, but at this stage I'll keep to myself. But what underlying interest is holding member states back from looking at harmonization? And on that note, we will end this part of the podcast. I really need to say thank you to both of you because you accepted on short notice and also being so well prepared.
Thank you.
I am sure our audience will appreciate it. Thank you so much. And we will be back with you shortly with our new guest in order to continue this discussion. Thank you very much.
Thank you.
Thank you.
Good morning and welcome to the third part of this podcast, which we are hosting to discuss the impact on operators. In front of me, I have Dario from Betsson, whom I would like to thank for accepting this invite on such short notice and who has also kindly accepted our invite to provide his input on the decision and how it will or possibly affect the industry. Good morning and thank you, Dario.
Good morning and thanks for inviting me.
Dario, I will start where I started the first podcast, which is the statement the MGA issued in reaction to the Winner case, in which, in my opinion, the MGA said this is business as usual. Is that the case for Betsson?
So, what I think in general, Trevor, is that the regulatory landscape has drastically changed. Now we are speaking here about, let's say, cases related like to operations that took place many years ago, like under different, let's say, sometimes in some jurisdictions under a completely different framework. And the regulatory, let's say, landscape has drastically changed in the sense that many regulations started introducing its own licensing regime. Many operators that used to operate in some let's say, of these countries pursuant to the MGA license and then over the years then obtained a local license and switched, let's say, to local, let's say, regulated operations. So I would say that in a way, like the MGA license, cannot be used as it was used like in the past. This is like the current reality. And but what I think in general is that speaking about this specific judgment, it doesn't have, let's say, an immediate impact on the industry in the sense that obviously, like the European Court of Justice didn't go into the merits of the case, and just, let's say, stated that when it comes, let's say, to the director's liability, arising like from let's say non-contractual obligation from tort law, that in any case the applicable law should be the one of the member states where the player resides,
Yes.
Which is
the point of consumption.
Yes, exactly, point of consumption. But obviously, then it will be an Austrian court to decide if the director was eventually personally liable for this kind of behavior. But besides the specific case, as I said, is that in general, I think that many operators have also changed approach.
Have evolved,
not only because of let's say the licensing regime being introduced in many jurisdictions, but also as a matter of reputation, no? Like, if I'm not mistaken, going back to like the previous part of this podcast, no? There was like Franklin that mentioned, speaking about director's liability, also say, as this may have an impact also in terms of reputation, no?
Yeah.
Because sometimes you may change approach, or you may want to minimize risk as a matter of reputation. This is also what many operators are doing, because especially nowadays that we are seeing a sort of consolidation, no, in the gaming industry, like big groups in any case are acquiring, let's say, small operators, which then become part of international, like worldwide established iGaming, let's say, groups, also, let's say, listed on the stock exchange. Like, so it's also a matter of, let's say, avoiding sometimes to go into certain jurisdictions, or avoid, let's say, facing certain challenges in order, let's say, obviously, like to also keep attracting investors and also, let's say, not having any impact in terms of reputation. That's why, like, I think that the current situation is completely different from the previous.
So, in your opinion, it is business as usual.
It is business as usual but with respect to like different geographical region, or like a different, let's say, can be business as usual, but with respect to like a small number of markets, like not comparable to the past.
Okay. So, if I am not mistaken, Betsson do have a number of these cases, right? Does this decision in any way affect the way you approach those cases? So, is it business as usual now? Before it was more for the industry. If I may.
Yeah, sure.
Dario, if I'm extending my remit, you correct me.
Yeah.
But if I may, and without revealing too much on how you're tackling these cases, but is it business as usual for Betsson?
I wouldn't say so,
No.
to be honest. Like,
Why?
In the sense that, as I said, because like speaking about big international groups like Betsson is, no, and like also listed on the stock exchange, and there are like several aspects that needs to be taken into consideration when it comes, let's say, to reputation, but also, let's say, the way you operate, that should be done in a certain way that you keep attracting, let's say, investors, no. And you have also, let's say, some also because you are like licensed in many other jurisdictions, no, holding, let's say, over 20 licenses like worldwide. The way you operate sometimes, no, if you like face some challenges in some jurisdictions, this may have an impact also in regulated markets, because of like reputation wise, but also in regulated markets, because sometimes you need to report to some regulators also like fines, let's say, or warnings that you receive from other authorities in other markets. And also, like, speaking about new markets, when you need to file, when you need to submit a license application, you need sometimes to disclose obviously like ongoing challenges with, let's say, local authorities in some other states, or like if you in any case receive a fine, or in any case if you have like pending litigations and the subject matter of such pending litigations in other states, and this may have an impact on your license application. Or if you already have a license, you're already operating, let's say, pursuant to that local license, this may have an impact on the ongoing, let's say, operations in that specific regulated market. That's why I think that in general, like it's, let's say, the situation is completely different from one perspective, because like the regulatory landscape has changed, but like on the other end also because operators, as a matter, let's say, of risk governance and the minimization of risk, they try, let's say, to avoid certain risks in order, let's say, also to protect their, let's say, regulated operations and their, let's say, global reputation. So this is what I think in general about that.
Okay. So this leads me to a two-pronged question. So operators have changed their approach from when Warner was originally filed in Austria. We're talking, what, 7-8 years ago? Until we came to this decision.
Yep.
Justice takes a long time.
Yep.
Especially in these matters. So there's been a change of approach from 7-8 years ago till today, which makes the status quo in, let's say, 2017, 2018, much different to 2025, 2026. And you want to talk about, and you have talked about taking on an approach which also makes sure that you attract investors, you're risk adverse. Has there been, again, if I'm asking too much, you stop me, but has there been any notion, any discussion, any thought given to settling these issues?
I mean, like settling these issues, yes. Like this is something that is an approach that several operators took. In some cases, some Austrian cases, German cases have been settled. Like in the past, this is also, let's say.
We don't need to mention other operators.
No,
by
exactly.
name, but,
yes, exactly. No, but in any case, it's like. Is known like in the industry that like some cases have been settled. It's also like a legal strategy, no? That like operators in any case decide. So some cases can be settled, some other cases are being challenged like before the competent, let's say, tribunals. But in a way, it depends also on let's say the legal arguments that you want to bring, no? And I'm very much aligned with the arguments that Franklin and say Michele, no, raised, say in the previous part of the podcast, in the sense that since we are speaking about 10 years ago, or like a different, let's say, framework, and we are speaking about countries or frameworks where at the time was not possible like to apply for a local license, because there was no possibility like for operators based on another member state to apply for a license. And in any case, this kind of systems were in contrast with the framework, the Maltese framework when it comes, let's say, to online gambling. Now seeing, let's say, Malta as a point of supply, allowing operators, let's say, to operate on a cross-border basis, provided that they have a lawful, let's say, reason like for doing so. And this is like. I think that since we are speaking about 10 years ago, and if you have like good legal arguments, because I think that we have like as an industry good legal arguments to fight against this case, I think that then there is like the need also, let's say, to try to legally challenge such cases like before the tribunals. Then when it comes to settle, this can be like any settlement, no? This decision like can be motivated by several reasons. No, it can be like because of the peculiarities of that specific case, because of the amount, because of like a certain specific.
I think a mistake is made by many stakeholders in these issues, where we seem to grab the Austrian cases and we just put all the cases in one envelope, when in reality each player is a different reality, is a different gameplay, different typology of games that the player plays. So it's not a one envelope which collects all, right?
No, correct.
So it's very subjective. Now, I'd like to specifically, Wooner looks into the issue of Austria. In the first part of the podcast, an interesting point was made that Austria is basically saying, okay, there are these issues, but at the same time, I'm going to levy a tax on those operators targeting Austrian citizens. Isn't that a form of tacit acceptance, in your opinion, or a legitimate expectation, to use the words Franklin used before, that if I'm paying the tax, I can operate? So you're taking my tax money, but then you're suing me at the same time.
I mean, yes, no, it is like a bit of a contradiction, no? And it's quite an evident contradiction. So probably like if we want to say, going back to what Franklin was said, probably like that's why a more aggressive approach probably could have been taken in order, let's say, to go against this kind of, let's say, approach, this kind of like regime, no? In order, in any case, to try to fight it, let's say, in a proactive manner rather than, let's say, than only like from an enforcement, let's say,
or legislative
through Bill
55.
Through Bill 55, yes, as transposed like in Article 56A of the Gaming Act. But yes, so that it is like, and it is interesting, obviously, like to to see how the situation is going to evolve. What I think, Trevor, like in general, not because we are speaking about now the impact of these cases and also like the impact of this ongoing discussion, no? Between, let's say, Malta and the European Union, also like speaking about the infringement like procedure that like the European Commission opened against Malta for Article 56A. What I think in general is that now, like, everyone is speaking about Article 56A and Bill 55, which in the end, as like also the MGA stated, didn't add anything.
This is not linked to Bill 55, to Article 56A.
Exactly. This is different. Like, and also like Article 56A didn't expand when it didn't expand, let's say, the grounds. According to which, let's say, a member state can refuse the recognition, can refuse, let's say, the recognition of foreign judgment. No, because it's just, if you want to see it in this way, what Article 56A is a reflection of, let's say, a long-standing policy of Malta when it comes to iGaming, like well-established principles of
policy.
Exactly, of Malta that already, let's say, used to exist in Maltese, let's say, regulation, and also a reflection of like EU principles when it comes to freedom of services and like freedom of establishment.
And it was a well-established practice as well.
Exactly. So what I think is that now, seeing this from an operator perspective, that like any case may be impacted, by any kind of development of this kind of cases, of this kind of decisions. Obviously, like if something's gonna happen to Article 56A, if Article 56A is repealed, for example, like in the future, because of
the ECJ decisions,
or like the infringement procedure, like opened by European Commission, I still think that from a legal perspective, as long as we can defend any refusal, let's say, of foreign enforcement for a judgment on the basis of Brussels 1 recast regulation, so let's say because they are against the public policy of Malta, because of, let's say, the gambling framework, like, or the Maltese gambling framework, I think that like we still have legal arguments that like can be used besides and beyond.
So if I may ask this question, follow up directly, Dario, I'm sorry I interrupted. So if I'm understanding correctly, do you see it that, let's say, we lose the protection of Article 56A through the Commission infringement proceedings? We lose that protection. Good. But we've still got Brussels 1 as a safety net.
Yes, because like what I think...
So Brussels 1 would be like, okay, we've lost one layer, we've still got the other one.
Exactly. Because what I think, but this is obviously like personal opinion, and obviously I don't want to...
Listen, we're lawyers, everyone has opinions. We don't have opinions.
I don't want to go into, let's say, the legal details or technicalities like of any decision that, let's say, Maltese tribunal may take after the eventual, let's say, repealment of Article 56A. But should this happen, what I think is that when you refuse, let's say, a judge, the enforcement for a judgment, you do this because you think that that judgment, or like also the framework, under which the judgment, the events, occurred, are against the public policy of your member state, and this is something that like the public policy of Malta when it comes to gambling, is something that it already existed before, let's say, the introduction of Article 56A, which in any case, in a way, gave an asset to multi-school for the time being, because now, specifically about gaming, you know how to link, let's say, the public policy of gaming to the Gaming Act, because there is a specific article, making reference to it. But even without this article,
we've still got Brussels.
And we can still say that, let's say,
so we have that safety net. So this is your argument over here.
We can still say that Maltese framework when it comes to gambling is is like a long-standing policy.
What if so a further question here. How do you feel about the position as an operator that you have the government of Malta, which is, and here, be it any political party in government, because online gaming has spanned a lot of years. You look at the position that Malta takes, Does that give you peace of mind that, yes, I've got the government in my corner? I've got the Maltese government. I know I have a reliable partner which will back me up. Does that give you peace of mind?
Obviously, like what I think is that Malta has been, let's say, always good like to the gaming industry, and the gaming industry has always been good like to Malta, no? Yeah. So obviously, like there is this kind of
it's a two-way relationship.
Exactly, like relationship. Obviously, like what I think is that it's good to have like to have good conditions, like favorable conditions when when speak about the gambling companies. To operate like from Malta, to establish, let's say, a business here in Malta. And what I think is that also going back and also expanding a bit the discussion here, speaking about, let's say, the Maltese, let's say, framework nowadays when it comes to iGaming, and also, let's say, how Malta can keep attracting, let's say, investments here, even despite like let's call it in this way, no? The reduction of when it comes to the use of the MG license, no? Because I think that nowadays we shouldn't, let's say, focus too much on how much I can use, let's say, or when I can use, let's say, the MGA license, or shall I move to Malta just because I want to use the MGA license, let's say, on a cross-border basis. I think that Malta over the years has really become a hub for, let's say, gambling companies. Many many professionals live and work here in Malta. Knowledge can be shared here, like in Malta and from Malta. And I think that Malta is still, let's say, a hub when it comes to, say, to technology, digital solution and innovation. And in this way, that, in my opinion, Malta in the mid-long term can still attract investment and professional and companies here, despite anything that like will happen to like
on an ECJ level or a commission level,
and also like on the possibility to use in the future, let's say, the MGA license.
When I used to work at the regulator and when I worked in-house in the industry, one of the complaints against the industry was we always went our own individual way, even from a lobbying perspective. So my last question to you is this: do you believe that the industry has changed its approach and has taken a more collegiate, common level to lobbying, and lobbying as an industry rather than as individual companies? Or are we still selfish?
No, I think that, especially when it comes to some topics, like that have, let's say, may affect like more than one operator, like, or the industry, like, in its in almost its entirety, and we are speaking here about one of these topics, actually, when I think that like there are topics that may have a negative impact on the industry in general, I think that we are, let's say, quite mature in this sense, like we can come to, let's say, a common ground and fight, let's say, as an industry against, let's say, anything that may have, let's say, adverse, let's say, impact on our industry. So I think that in this way, but also, let's say, when it comes to anything that can give an advantage, like to operators, like, or to the industry in general. I speak about also like for example, now moving to other topics, also when it comes to new regulation that are being implemented, like in some countries, and like, I don't know, gambling bill that are for which, for example, there is an open public consultation going on. Also, in this respect, like, the industry is quite compact when it comes, let's say, to which kind of feedback and comments like are given to this kind of, let's say, new regulations in order, let's say, to protect and safeguard, let's say, the industry interests, So I think that over the years, the approach has changed, and I think that like the industry is quite
more collegiate, more together,
more together, especially like when it comes to any kind of topics that can have an impact like on the industry's, in its entirety. So this is like what I think, and I've seen this not only like in this case, as I said, like in many other occasions. So there are like common, obviously, like there still can be some small differences,
Yes.
And some conditions in certain market can be, let's say, an advantage for certain operators, or like a disadvantage for other operators. Also, in terms of, say, the way of sites, or for other reasons. But what I think is that yes, there now also, like, speaking about lobbying, because you mentioned also, like, from a lobby perspective, no. In several, like, jurisdictions, like, the operators are together fighting,
Yes.
say, together through, associations for, like, the industry interests. So I think that they are working quite well together, operators nowadays.
Dario, thank you so much. I really appreciate you joining us. I also appreciate the patience you had, because you had to wait till...
No problem at all. Thanks for having me here. It was a pleasure.
Thank you for your input. I would like to thank Sigma and the entire team who really helped in setting up this podcast in such a short time. I'd also like to thank the MGA. I'd like to thank the MGA's office for sending us that statement and for providing their position, which we also reproduced over here, word by word. And I'd like to thank you, the viewers of the Sigma podcast, for ensuring that we continue to grow this series. And I'd urge you to like and subscribe the page of Sigma on YouTube in order to keep more up to date with what is going on the channel. Thank you very much, Dario.
Thank you, Trevor.
Thank you so much, and I wish you a good day ahead.